All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Good morning, everyone. I am Chief Justice Sarah Stewart. It's great to see everybody. I will go ahead and tell you this is only my second oral argument, so if I mess things up, I'm still learning how to do this part of my job. But I did want to thank President Kit again for his warm welcome and all of the staff. Y'all were so great to us last night, and we had a really great time. The justices, we really have enjoyed coming to Florence, and you are very justifiably proud of Florence and your university. So thank you for all of that. I wanted to take just a second to explain to the students and for others that might be not familiar with how oral arguments work. So we are getting ready, and these people here are very nervous and are ready to argue. And each side gets 20 minutes to talk. And the petitioner who has filed this writ of mandamus petition with us gets to go first, and they also get to go last because they have the burden of proof. And they'll decide how much of their 20 minutes that they want to use in their initial arguments. Then after that, the respondent will get to use their full 20 minutes, and then whatever time is left for the petitioner, they will be able to go. We have red, yellow, and green lights on the podium in front, and generally that's supposed to tell the lawyers they're about to stop their time, and when the lights turn red, they're supposed to stop talking. So we work on that. But we're very excited about being here, and we hope that this is of interest to all of you. After we hear the arguments, we will adjourn, and we will take this under submission and hopefully get an opinion out within a couple of months at most. So thank you all very much for being here. I wanted to introduce the court real quick. Justice McCool, you want to start?
Sure. I'm Chris McCool. I'm from Gordo, Alabama, and I'm happy to be here.
Hey, Will Sellers, Montgomery, Alabama.
Kelly Wise, Montgomery, Alabama.
Sarah Stewart, Mobile, Alabama.
Greg Shaw, Daviston, Alabama.
Tommy Bryan, Brantley, Alabama.
I'm Brad Mendham from Dothan, Alabama.
I'm Greg Cook. I live in Vestavia Hills, but originally from Florence, and I want to claim being an alumni of the university.
All right, are the parties ready?
Madam Chief Justice, and may it please the court. This case is about whether this court will affirm its long-standing precedent granting state immunity to a sheriff and a deputy sheriff when acting within the line and scope of their duties. Article 1, Section 14 states that the state of Alabama shall never be made a defendant in a court of law or equity. Under Article 5, Section 112, the Constitution lists the members of the Executive Department of State Government. These are also referred to as constitutional officers. It lists the governor, lieutenant governor, attorney general, other officers, and a sheriff for each county. All but one of these are elected officials. In Montiel versus Holcomb, this court held that a suit against a sheriff is in essence a suit against the state. In 1917, this court in Ex parte State Ex rel Martin held that the state has a manifest interest in and concern for the observance and enforcement of its criminal laws, and in the freedom of its officers to perform their duty in the detection of offenses and offenders against its laws. To restrain the sheriff and his deputies in that regard impinges upon, brings into question the powers of the state itself. This court in Parker versus Amerson in 1987 laid out the history behind the 1901 Constitution.
So counsel, just to be clear, the first time our court recognized constitutional immunity for sheriffs was in 1987,
Yes, Your Honor.
even though the Constitution was passed in 1901.
Now, there were other cases involving the sheriff before then, Montiel versus Holcomb being one.
That was an official capacity claim.
Yes. Yes.
So when was the first time we recognized immunity, constitutional immunity for a deputy?
For Deputy B. Hereford versus Jefferson County in 1991, Your Honor. And as this court has held in Melton versus Espy in 1978, the prohibition of Section 14 cannot be circumvented simply by suing an officer or agent, official or agent individually. And that's why even in the Parker versus Amerson case, Sheriff Amerson was sued individually and in his official capacity. And that's why it's important to what was he doing? What were the actions he took? If you apply that in this case, for instance, the complaint alleges that the sheriff at all times was the sheriff of Walker County. It says the Deputy Miles was at all times relevant to the complaint, a deputy sheriff. As deputy sheriff, Miles was assigned to the patrol division and responsible for the performance of law enforcement duties. In paragraph 9 of the complaint, while patrolling rural Walker County, Defendant Miles attempted to stop a suspect riding a motorcycle believed to be stolen who committed a traffic violation. Paragraph 10, the suspect refused to stop and accelerated quickly to speeds in excess of 100 miles per hour, and defendant activated his lights and siren and pursued the suspect in hot pursuit.
Yeah, and I'm pretty convinced that the complaint creates a line and scope inference. I'm pretty convinced by that, just to be honest. But what I'm not convinced by is that why the deputy should have different immunity than a regular police officer. And you're asking for absolute immunity from civil damages, right?
Yes, Your Honor, state immunity. The reason why is, and this came from Hereford, quoting other cases, Mosley versus Kennedy, and even going back to the Carroll case in 1890, Rogers versus Carroll, where it held that a deputy sheriff is the alter ego of the sheriff. In essence, they are the same person. They are one person, legally speaking.
And at that time, the question was imputing liability to the sheriff for acts done by the deputy, correct? In those cases that you cited.
Yes, Your Honor, but that's also for the actions that the deputy took.
Right, and so there was the sheriff could be liable, not immune, but liable for the actions taken by the deputy in those two cases,
yes,
right?
because the deputy is acting for the sheriff.
Right, and today you're asking that you turn that upside down, that you have immunity that would flow from the sheriff down to the deputy instead of liability flowing from the deputy up to the sheriff.
No, Your Honor, we're asking this court to reaffirm its longstanding precedent, Hereford versus Jefferson County, Drain versus Odom, Carrick versus Johnson, the ex parte McWhorter, ex parte Davis, ex parte, I can list over 20 cases.
Right, that are all from 1987 forward, right?
Yes, Your
Before
Honor.
1987.
And it was during that time we have had an explosion of tort liability from the 70s forward. So yes, Your Honor, it was since 1991, the Hereford versus Jefferson County case, where this court has held that. And it's interesting looking at ex parte Shelley, where this court rejected state immunity on behalf of a jailer. Why did it do that? This court distinguished between the role of a jailer and the role of a deputy sheriff. And it says a jailer is not the same as a deputy sheriff. The deputy sheriff is the alter ego of the sheriff. The deputy sheriff is the legal extension of. And it distinguished that. That's why the deputy sheriff receives the state immunity and the jailer does not.
So to be clear, though, the alter ego ruling that we've made, that's judge-made precedent, right? That's not in the Constitution.
I'm sorry, Your Honor.
The doctrine you referenced, that the deputy is
Yes.
the alter ego of the sheriff, that's judicial precedent. That's not words from our Constitution, correct?
That's correct.
And so in 2011, our legislature passed a law after Shelley was decided, correct?
Yes, Your Honor.
And so in Shelley, they decided the jailer and the deputy were different. The deputy got immunity, the jailer did not get immunity, right?
Yes, Your Honor.
And then in 2011, the legislature passed a law and said both of them are going to be treated the same, right?
Not entirely, Your Honor. And it's referred to as the Jailer Liability Protection Act, which was passed in 2011. The Shelley case was issued in September of 2009. The legislative session where they could really address it would have been the one following the 2010-2011. If you look at the synopsis of that act, it states that it was designed to give the jailers the same immunity as the sheriffs. Okay?
And that was the synopsis of the original bill, not synopsis of the bill that got
But it
passed.
was amended,
right?
Your Honor. Yes.
So the original bill said that they were going to get complete immunity, the same as the sheriff, and the bill that got passed said they got immunity as long as they were in the line of scope and in compliance with the law, right?
Yes, Your Honor.
So the legislature has passed a law telling us when deputies get immunity.
Your Honor, it was a supplemental immunity. It was different from the original immunity. The legislature, as this court held in Parker versus Amerson, where there's a provision in Alabama Code Section 14-6-1 that states the sheriff shall be civilly responsible for the actions of a jailer. In Parker versus Amerson, this court said that provision of 14-6-1 was unconstitutional. And it was a violation of the separation of powers for the legislature to put that in and to place immunity on the sheriff where immunity did not exist because of Article 1, Section 14. The same reasoning applies with this provision to the extent it differs from state immunity.
So are you telling me that provision of 36-22-3 that got passed in 2011 is unconstitutional?
I'm saying, Your Honor, that it is a different form of immunity.
It says you get immunity only as long as these two conditions are met.
Yes, Your Honor, but to the extent it conflicts with state immunity in Article 1, Section 14, it is different. We are relying on Article 1, Section 14 immunity in this case for the deputy sheriff and for the sheriff, Your Honor.
You want us not to follow the literal text of this statute?
We want you to follow Article 1, Section 14 and the case law interpreting Article 1, Section 14 as it applies to the sheriff and deputy sheriffs. Yes, Your Honor. So it's the long-standing precedent. We request this court reaffirm that precedent that this court has already set.
So to be clear, are you saying that 36-22-3? I'm not following you completely. It does not conflict with Section 14, or are you saying it does, and we need to follow
Your Honor,
the constitutional
I think
provision?
It does.
Okay.
But I think, in my opinion, Your Honor, we argue that it is a supplemental form of. Your Honor, my time is up. May I respond to this question? We're arguing it's just a supplemental form of immunity.
And not necessarily that it conflicts.
Not necessarily that it conflicts, but because there is a difference, it is a supplemental form of immunity.
Okay.
It is an additional form.
Thank you, Counsel.
Thank you, Your Honor.
May it please the court, Robert Overing for the state of Alabama. The rule the court affirms here will affect all constitutional officers, from the governor to the attorney general, each of whom acts on the state's behalf. It is vital that constitutional officers discharge their duties through bold and unflinching action. Their decision-making cannot be distorted, nor their attention diverted by the threat of civil damages. An executive in perpetual fear of personal liability is a weak executive. For these reasons of constitutional structure, the court has long restricted jurisdiction to only claims against the state for injunctive and declaratory relief. Ruling for respondent would mean overturning decades of precedent dating back at least to Parker versus Amerson. The court should instead reaffirm its constitutional officer jurisprudence, preserve the separation of powers, and issue a writ of mandamus ordering the circuit court to dismiss this case. The court should follow the United States Supreme Court and identify a need for immunity in the very structure of the executive branch, the essence of executive power, which has been the federal government's position from the 1800s through today. In Nixon versus Fitzgerald, the Supreme Court held that a former president is absolutely immune from civil damages for his official acts. Why? Because without immunity, officials would hesitate when the public interest requires bold and unhesitating action. Fear of liability corrupts executive power, and that holding was emphatically reaffirmed last term in United States versus Trump, which held that the president cannot be criminally prosecuted for acts within the scope of his official duties.
Counsel, I recognize that those cases, and I recognize that might be true for the governor and perhaps true for the sheriff. Do you think that's true for the deputy?
It's true for the deputy because it's true for the sheriff under longstanding precedent.
But that's just precedent. That's not the Constitution.
Well, I think the Sheriff's Association brief goes back through centuries of precedent, from Blackstone to Justice Story, and detailing the common law role of the sheriff as the keeper of the king's peace, and then the deputy as his alter ego. And I think there's a persuasive case that emanates from the common law, and nothing in Alabama law has purported to abrogate those rights and immunities of the deputy.
So the U.S. Supreme Court's adopted a functional approach, right, for making that immunity decision.
That's right, Your Honor.
So the sheriff here has been alleged that he didn't make the right policies. That's one of the allegations against him. For instance, the policies about the high-speed pursuit. That sounds very executive to me. I mean, I'm understanding your argument. I sympathize with the argument you're making. The deputy, on the other hand, is out there driving down the road trying to catch the bad guys. Doesn't sound very executive to me, and I'd have difficulty understanding why that's an executive function and fits within the functional analysis case law of the U.S. Supreme Court.
It is true that other police officers, municipal officers, exercise similar functions, but it doesn't take away from the fact that one of the sheriff's key jobs, defined by statute and probably historically grounded as well, is to ferret out crime. And so pursuing, apprehending, arresting a criminal suspect is a core part of the function of the sheriff. The Attorney General may do things that other lawyers in the office do. He may make a filing, he may send a letter, but it doesn't mean he's any less immune. And consider the consequences for our structure of government if it were so easy to pierce immunity based on the allegations here. The allegation is that Deputy Sheriff Miles had a personal motive to apprehend a fleeing suspect.
I'm not buying that argument, so I'm with you.
But it illustrates the dangers of applying state agent immunity to these high-ranking executive officials. All anyone would have to say is that the Attorney General of the state prosecuted me or launched an investigation out of
It's the function. It's the function test from the U.S. Supreme Court, whether that officer is doing a function that's in the nature of the executive, right?
That's right, Your Honor. And so we would urge the court to follow those federal precedents and say that for those core executive functions that are well within the scope of, in the line and scope of an official's duties, those are ones for which he is absolutely immune.
Mr. Irving, your time is up.
Thank you.
Okay. Madam Clerk, if you would add the time that he went over and Mr. Webb to their time. Okay. I think Mr. Tatum, you're ready?
May it please the court. I will say first, I have argued 12 14 cases before the 11th Circuit and only once before this court. And that was in the Meadows case. And in one of the briefs, you will have read it, it said that this court self-corrected some of its precedent in the Taylor case. And the first thing I want to say is I don't see it as being self-correcting, because I think Meadows helped to get us to where we are today. But I speak of my history in arguing cases before the court to say this has been truly the most difficult case for me to prepare an argument for. And there's a reason for it. And the reason is really simple. It's because there are cases that, not meaning to be critical in the wrong spirit, but I think as Justice Mitchell said in his concurring opinion, the decisions, he characterized them as being haphazard. And in fact, trying to reconcile the different decisions from the Supreme Court on this issue has been overwhelming for me. And I respectfully submit to the court. Well, first I want to say thank you, because it is difficult to say we got something wrong. But you did that in Taylor. And by doing that, what you did is you opened the door to the courts for the citizens of Alabama when they have been exposed to torturous or wrongful conduct by someone who was acting on behalf of the state. And that wasn't anything extraordinary, as has been alluded to by Justice Cook. Up until 1987, the Parker case, the door was always open for torturous, wrongful conduct committed even by state actors or state officials. But some way, somehow, Parker has been taken and it morphed into something that I don't think the court ever intended it to be. And so you self-corrected, I'll use that term, in Taylor, and that was a good thing. And I respectfully submit that now it is time for you to consider fully correct this problem. And by doing so, you will make the practice of law easier for the lawyers, simpler for the judges. But the question, the magic question is, how do you do that now? Justice Cook, I'll be honest with you, you've got me worried because you alluded to adopting a test that would address the function of the officer or the official at the time. And I'll be very honest with you, I read the U.S. Supreme Court's take on this. And I want to submit to the court that Alabama is different. The United States Constitution is different than the Alabama Constitution. And as a result, adopting a function test is almost what we had when we were talking about ministerial versus discretionary. And I ask, please don't throw us back into that bush, because we struggled with that. I, as a lawyer, I know you as lawyers, when you practice, and I know you as a court, struggle with those decisions too. And I guess 38 years or so, I'm tired of struggling with legal issues. So I don't know that you're going to be helping us a whole lot if you adopt a function test.
Well, I'm struggling with, in 112, Section 112 of the Constitution, we got these lists of all these officers, including the state auditor sitting on the front row. He's on the list. Okay, so we'll just start with the governor. Okay, if the governor makes a decision that's an executive decision on a policy matter, Maybe the governor, maybe she ran on a particular policy matter, and the people of Alabama voted for that policy. I'm having difficulty understanding how that's not constitutionally part of the separation of powers, and I'm not supposed to get involved in overruling that policy decision.
The Constitution and how you approach constitutional analysis, I think, answers the question, because I would struggle with that if I was sitting in your seat, because the separation of powers is real and it is necessary. However, I think that any answer to the question, I think you have to start with the language of the Constitution, and that, fortunately for all of us, is straightforward. Article 5 lists who the executive officers are in the state, and it goes no further. So what?
The sheriff's one of them.
And the sheriff is one of them. But Section 14 says something different. That's the source of the immunity, not Article 5. Article 5 says nothing about immunity. So you have to go to the actual context of the Constitution, and it simply says this: the state of Alabama shall never be made a defendant in a court of law or equity. Now, what is the state of Alabama? One would think that's a simple question with a simple answer. And I submit to you that historically it has been. You allude to the case of Rogers v. Carroll back in 1907. The sheriff was sued in that case. There was a question of whether the sheriff was going to be liable for the acts of his deputy. But there was no question as to whether the sheriff could be sued then.
Mm-hmm. True.
And so, you say in 1901, but I submit to you that in 1875, the language in Article 1, Section 14 was the exact same. And then, so there's really no question as to whether the sheriff could be sued in some capacity or some form. And quite frankly, Carroll does not make clear whether the suit was in individual or official capacity. But we must assume, in order to construe the case law as making sense, that the justices back then know, just like you all know, that if this suit has been in his official capacity suing him as the state of Alabama, that clearly the language in the Constitution said you can't do that. So despite the fact that I would have problems if the governor was sued in her personal capacity for something she did, that's just part of what is required under our Constitution. And what is required is not that the court pass a rule that affords immunity. What is required is that the court apply the Constitution as it is written.
But there's a separation of powers provision in our Constitution. It is expressly says that we have separation of powers. And so if we are allowing an attack on an executive decision, a policy-making decision of one of our highest apex policy people, like the governor, for instance, you're going to be able to harass her and file multitudes of lawsuits so she can't do her job. And the same thing could happen to the sheriff. Let's imagine the sheriff here had run for election on a policy that he was going to chase every bad guy, no matter how fast they were going, no matter what road they took. He was going to chase them until the end of the earth. And the people of Walker County said, yep, we want that kind of sheriff. That's a policy decision. And our Constitution says we're not supposed to invade the executive.
I think that you just have to deal with the issues as they are raised. And I can't foresee a situation where me as a plaintiff's lawyer, as I've been all my life, would be filing that lawsuit that you're proposing, hypothetically or otherwise, because I understand and I am prohibited from filing a suit against the sheriff in his official capacity. And other than that, any lawsuit against him in his personal capacity should be judged by the rules of law.
But you sued this sheriff because he didn't make a policy. that would prevent his deputies from chasing people in high-speed chases, even if they were criminals.
That's correct. That is correct. But we sued him as an individual, saying that he was negligent. And the court has historically said that claims of negligence, torts, are claims that can be asserted against an individual. So if, in fact, our claim fails, it does not fail because it is prohibited by Article 1, Section 14. It fails on the merits.
So let me switch topics just a little bit. So here, the allegation, as I understand it, is that the deputy chased this person in high-speed chase through Walker County, and the bad guy then hit the victim, right?
That's correct.
So the deputy didn't hit the victim, right?
Yeah.
Don't we have case law, the city of Warrior, that says that any peace officer chasing somebody has the right to do that, and that any effect on that person is not the responsibility of the peace officer who's doing this chase?
Again, I think, as I see your question, I think that you're past the issue that has been raised at this point in the proceeding.
Perhaps.
And so when you get to merit-based, fact-based analysis, then I submit and respectfully request that rather than the court engaging in that the court deny the petition for writ of mandamus, because the petitioners did not raise qualified or state agent or any fact-based immunity. They instead chose to argue that the court lacked jurisdiction over the individual capacity claims, and that simply is not a correct statement of the law.
So can we not look to the facts of the case in deciding how we're going to handle this writ of mandamus? I mean, the facts seem like they may not be on your side based on our history. I mean, you got an accident that was not necessarily caused by the deputy. It was caused by the person that was chasing him. And it seems like our case law is there. And for judicial economy, if nothing else, surely we should be able to look at the case in its entirety. Who's got a complaint? It's a motion to dismiss. And in a motion to dismiss, we look at the four corners of the complaint. So we consider all those things. So can't we get to the facts and look at that and compare that and make a decision based on that? Or are we simply limited to only focusing on this immunity issue and what it may or may not mean, and can't ultimately look at the holistic view of a case?
My answer to your question, and I don't mean to be over presumptive or to sit into your chair, but the answer to your question as I see it is absolutely not.
Thank you.
Absolutely not. This court has steadfastly required that issues first be addressed at the trial level before this court would review them when making a decision about whether to overturn a trial court. Now, a different rule applies when the court is reviewing to make a decision as to whether it will affirm the trial court's decision. And the rule is that you affirm for any reason. So if the trial court gets it wrong, but you see a legal reason or other reason to affirm, you still affirm. But in this situation, the facts haven't been developed. And my client, I respectfully submit, has the right to develop those bad facts. And I know more about the facts, and I know it's not proper for me to speak about things outside the record, so I won't. But I request the opportunity to do so in accordance with what precedent says we're allowed to do. And I do want to say this. There are two cases that this court, I would request the court consider, as my time is getting near an end.
Counsel, before you go there, can I take you back to the language of Section 14?
Yes.
And the language of Section 112?
Yes.
Designating the executive offices. Is it possible for the state of Alabama to do anything without doing it through people?
No. No, the state of Alabama acts through people. The problem is, though, that sometimes people do things wrong. And when those wrongs are committed, those wrongs are not the state of Alabama. Those wrongs are the individuals who are committing the wrong. And we cite the cases that stand for that proposition. There's a long line of them. So when that person who is acting for the state of Alabama commits a tort against my client, then I have a right to go to court under the Alabama Constitution and to raise that issue. My claim may fail. It may be bad facts, and I may lose, but I do have a right to go to court. Please consider White v. Birchfield. In that case, yes, the site is 582 Southern 2nd. My time is up.
Will you finish giving her the site?
Yes.
In the second case as well.
Thank you. The citation is 582 Southern 2nd, 1085. That's the Supreme Court. It's 1991. That's actually Mr. Webb's and Ely's case. So they don't mention it in their brief, but please read it because it answers the question before the court. And the other case is Coleman v. Dothan. The site is 598 Southern 2nd, 873. This a 1992 case as well. Thank you. My time went very quickly.
Thank you, Mr. Tatum.
Counsel. My name is Seth Diamond. I do want to quickly introduce John Long. He's in the blue shirt seated back there. He is the plaintiff in this case. This is his case, and obviously it is very important to him. I do want to go back and touch on Justice Cook's comments about deputy immunity. The petitioner's argument that the court treats constitutional officers different than officers created by a legislative enactment is belied when it comes down to deputy immunity. Deputies obviously are not mentioned in the Constitution. They are not Article 5, Section 112 officers. Deputies are created by legislative enactments. So how did we get to where we are that deputies claim that they are entitled to state immunity? And it was through judicial decree. And we can trace it back to the court's case of Hereford versus Jefferson County, which was published or released in August of 1991. That case was a claim against the deputy of Jefferson County who had negligently released the wrong inmate from jail, who got out on a crime spree and held up the plaintiff at gunpoint at an auto parts store. And the court at that time adopted the legal rationale from the 11th Circuit from Carr versus the City of Florence, where the court opined, which was released a year earlier, where the court opined that the deputy acts as the general agent of the sheriff, and therefore it is logical to conclude that they should enjoy the same immunity as the sheriff. Whether that is sound legal reasoning, though, is debatable.
Would the result have been the same if the deputy had acted wantonly?
I'm sorry.
So would the result in the case you're citing would be different? If he acted negligently, if he acted wantonly or intentionally, would the result have been different, do you think?
No, I don't think so, because the court at that time just said that they are blanket entitled to state immunity regardless of whether you were acting outside the scope of your authority or within the scope of your authority. It was just a jurisdictional, he is in fact the state. And that was, I don't think they ever get to the issue, and I don't think that would have mattered at the time. But I do want to answer your question because a year later, there's the case that was cited by Mr. Tatum, White versus Birchfield. It's significant because that case was released in June of 1991, 2 months before Hereford. And that issue that you just described, Justice Sellers, was before the court. In that case, a deputy was transporting an inmate to jail. He had just been arrested, and he got a call of a suicide attempt in progress, and he hurried off to render aid, and went over railroad tracks too quickly, and the arrestee hit his head in the roof of the car, so to speak, and filed a claim against the deputy for negligence for taking off such a high speed. And the court had a different result than Hereford. Just 2 months earlier, The court, as to the issue of immunity, said that the deputy was a state employee. And Article 1, Section 14 do not protect state employees for individual capacity claims who commit acts of negligence. Dare I say, I think the court got it right in that holding, but the court did go on to address your concerns. They applied a qualified or discretionary function immunity analysis. So the court in White versus Birchfield quickly disposed of the state immunity argument, and then it moved to a qualified or state agent immunity analysis and said that the officer was acting within his discretion, and we are going to protect discretionary acts, and afforded the officer qualified immunity. And I think that is the correct path for this court to adopt, because it is consistent with the legislative enactment of 3622(3), where the legislature has spoken to public policy that the deputy is entitled to immunity, provided that the deputy act in compliance with the law. And that condition is significant because the in compliance with the law provision is very similar in context and wording to the court's understanding of state agent immunity, a qualified immunity, that to be within the ambit of state agent immunity, you must as well be acting in compliance with the law on individual capacity claims, such that you cannot be violating the state law, a federal law, the Constitution, and you must be acting within the scope of your authority. So the legislative who speaks to the public policy is very close to state agent immunity, and that is the immunity that should be afforded to our deputies, as opposed to this alter ego theory that was developed by the courts in 1991. I see that my time is done. Thank you.
Thank you.
Hang on, Mr. Diamond. Justice Shaw has a question for you.
Yes, sir.
If you could just entertain one more question.
Yes, sir. I'd be happy to.
I want to take you back, as I did with co-counsel, to Section 14 and Section 112.
Yes.
Let's just take some examples. The governor acting within the line and scope. The state auditor acting within the line and scope. The attorney general acting within the line and scope. Secretary of State, lieutenant governor acting within the line and scope of duties. Can you articulate for me, why does Section 14 say what it says? Now, I know that there are some ideas. Protect the Treasury. Can't sue the state of Alabama to protect the Treasury. That's been articulated. Sovereignty, the idea of sovereignty, I believe the old common law idea of sovereignty of the king. Also, some ideas about ensuring that things are taken care of in society by people when other people don't want to do that. They do things that would subject them to liability. So we have Section 14. The state of Alabama shall never be made a defendant. So when the sheriff acts in the line and scope of his duties, how does the state of Alabama act or do anything unless it does it through people? I need a little help there, because somewhere behind Section 14 is a meaning, and it says the state of Alabama. When the sheriff is performing within the line and scope of his duties, and he is a member of the executive branch of state government under the Constitution, help me understand how you bifurcate that and you just say the state of Alabama exists in this ephemeral status here. But we've got the sheriff and we've got the governor and we've got the lieutenant governor and the auditor, and they exist over here. And you can sue them for damages, and you're not suing the state of Alabama. I really need to go back to bedrock on that.
Well,
and understand what your position is on that.
well, okay, so that was a big question. But if you're asking, is the source of the recovery, if the plaintiff is favorable, is that derived from the state or is that derived from the individual? And does that even matter to your question?
I'm just asking you to give me your take on what the state of Alabama is under Section 14.
Okay. My take was the court answered that issue in Ex parte Cranman, where the court said the state can do no wrong. It came from Old English common law, that the king can do no wrong. But under the English common law, they had the divine right of kings, and that kings were not answerable to any law of man, they were only answerable to God. But however, the court in Cranman also recognized that the king's ministers can commit a wrong. And when they do commit a wrong, they are not acting on behalf of the state. So you can preserve the integrity of the state and that it can do no wrong, and you can still hold the individual actors accountable in their individual capacity for when they do commit a wrong and not deprive the citizenry of its right for relief.
Was Cranman a Section 14 case?
That's interesting. It depends who you ask, because it was brought to the court as a Section 14 case, and it was decided as a Section 14 case. But as Justice Johnstone's concurring opinion, they don't even know why they brought the Constitution into it, because it was resolved on a restatement second of the torts and giving the actors a qualified immunity. And Justice Johnston would agree with you that it was not resolved through the Constitution, but it was an adoption of the restatement second of the torts and public policy.
Thank you. Appreciate it.
That's what it was. Thank you.
Thank you, Mr. Diamond. Mr. Webb?
I would like to first address the two cases they brought up regarding where deputies were not afforded the Article 1, Section 14 immunity, White versus Birchfield and Coleman versus City of Dothan. In between those two cases, you had Hereford versus Jefferson County. Directly after the Coleman versus City of Dothan case, you had the Wright versus Bailey. The White versus Birchfield and the Coleman versus City of Dothan, the court did not analyze alter ego, did not consider whether the deputies were the alter ego. However, it did in Hereford, did in Wright versus Bailey. Since the Wright versus Bailey in 1992, the court has been very consistent, approximately 20 cases where the deputies were considered the alter ego and were granted Article 1, Section 14 immunity, the same as the sheriff.
Have we ruled on an alter ego immunity for deputies since the 2011 Act?
Yes, Your Honor. There, just a minute. Ex parte Donaldson was around in that time frame, and the important thing I brought up before, the ex parte Shelley, where they distinguished that. I also want to bring up the Wheeler versus George, where the argument was made, well, this, the top assistant for the governor is basically the alter ego. And they again distinguished, no, it's not the same as the deputy sheriff, because the deputy sheriff is the alter ego. This theory goes way back into English common law. This is not a new theory. It's not, certainly it was addressed in Rogers versus Carroll in 1896, which was predated the 1901 Constitution. But this is not a new theory. This is well grounded in English common law. And it's even mentioned in not the alter ego specifically, but the sheriffs and the deputies.
And we've not had to deal with this statute, the 2011 statute. We've not had to deal with that yet. We've not construed that and how that interplays with the alter ego immunity.
No, Your Honor. But again, with respect to the amendment to Section 36-22-3, which is similar to the 14-6-1, because it occurred in the same act, our argument is a separate immunity. To the extent it tries to amend Article 1, Section 14 immunity, then it would be unconstitutional. But this court doesn't need to go there, because it is a supplemental form of immunity. There's legislation now to even add yet another form of immunity in the back.
It has conditional words in the statute. The statute has so long as, if I remember the language, it's conditional. The immunity is conditional in that statute.
Yes. Well,
it can't be supplementary.
Article 1, Section 14 immunity, to a certain extent, is conditional as well. The officer must act in the line of scope of the duties in order for the sheriff or his deputies to act as the state. And again, it's as this court in the ex parte state, ex rel Martin in 1917, again, the performing their duty in the detection of its offenses and offenders against its law, the sheriff and the deputies act. They're implementing the powers of the state itself. I mean, they are acting as the state when they're going about doing that. And again, it's sheriffs and deputies. It didn't say, no, it's just the sheriff, not the deputies. It said sheriffs and deputies. And this dates back again to 1917 because of, again, the understanding dating back to English common law that the deputy sheriff is the alter ego of the sheriff.
Did I understand you say a few minutes ago that these other constitutional officers do not enjoy these executive officers do not enjoy this constitutional immunity for the alter ego, such as their assistants? Is that what I heard?
No, Your Honor. The other constitutional officers enjoy the Article 1, Section 14 immunity. However, this court has ruled that just because you're employed by those constitutional officers, such as whether it's an employee of the governor's office.
Or a deputy attorney general.
Deputy attorney general. It could be. Again, but there's a reason why deputies are different from those, and that is the historical context that the deputy is acting as the sheriff when performing his duties.
Well, what about a deputy attorney general? Is he not acting as the alter ego of the attorney general when he's going into court filing briefs or making arguments, whatever?
And in that context, I would say yes. But again, that's, maybe an issue this court has to address in the future. But
it's not on point for this case.
When you're acting as the officer, okay, because certainly the Attorney General cannot sign everything, then certainly in that context, our argument would be yes, they would. But it's quite different from the ex parte Shelley and also the Wheeler versus George cases that this court decided.
And the Pinkard case was a deputy fire marshal, right?
Yes, Your Honor.
And we did not give them absolute immunity. We gave them the Cranman immunity, right? The qualified immunity. Even though the deputy fire marshal conceptually is a officer underneath the governor, right?
Working directly for the state fire marshal, who then works for the governor. But again, under Wheeler versus George, that they would not be considered the alter ego of the governor, which that would be what would need to happen in order for that officer to be entitled to Article 1, Section 14 immunity. And that's not the case. So that's why the Cranman immunity, the state agent immunity, would be applicable rather than the Article 1, Section 14 immunity.
So all those people in Section 112, the governor and lieutenant governor and sheriff and auditor, all those people are elected, right?
I believe there may be one that is not elected. I believe the superintendent for the Board of Education may not be, Your Honor. I haven't done research, but maybe one, Your Honor.
And so they are making executive policy. The sheriff here is making policy. They've alleged the sheriff was making a policy, right?
Yes.
Deputies don't make policy, right?
Deputies are the alter ego of the sheriff. There are situations where deputies are delegated the responsibility of making policies. Yes, Your Honor. I also wanted to bring up the ex parte Purvis case, where this court dealt with both what's considered the sixth exception and then said, no, that doesn't apply. But also an interesting thing is it analogized the immunity of a sheriff or deputy sheriff to the immunity of a state agency, citing to Ex parte Franklin Department of Human Resources. So it's just an interesting thing as to why the sheriff and deputy receives that same immunity as the state itself. Because you can't sue state agencies. You can't sue the state of Alabama. And again, this is why you can't sue the governor, the lieutenant governor, the attorney general, the sheriff.
Counsel, let's free ourselves from precedent.
I'm sorry, Your Honor?
Let's just free ourselves from precedent for the moment.
Okay.
And let's just look at the Constitution. Can you sue the state of Alabama without suing the sheriff?
If the sheriff is not acting within the line of scope of the
Okay,
case.
that's where I wanted to take you. Is it all about the line and scope? What is the sheriff doing? What is the deputy doing? What is the governor doing? What is the auditor doing? I'm trying. That's that provision in there. It's in there. It's in the Constitution. We're all bound by it. We have no authority to deviate from that language. The state of Alabama shall not be named a defendant. So it's been postulated by counsel on the other side that somehow this can be bifurcated and you can sue the sheriff and you can sue the auditor or the governor or whatever and still not be suing the state of Alabama. Conceptually, I am having a problem with that. And I know we've got cases, we've got precedent, and all those fit together like big pieces of a puzzle. But I'm just going back to the plain language of the Constitution and trying to figure out how you sue the sheriff without suing the state of Alabama.
You can answer the question, Mr. Webb.
Thank you, Your Honor. A sheriff or deputy sheriff can be sued for that when acting in the line of scope of their duties. Okay? If those 5 exceptions, as stated in Parker versus Amerson, are in there, which is actions to compel him to do
Equitable injunction.
equitable. Yes, Your Honor, and for declaratory relief.
Okay.
The limitation of acting in the line and scope of their duties is not, without it, there would be blanket immunity, but there isn't blanket immunity. This court has issued cases as to what constitutes line and scope of your duties. It addressed it even in the Ex parte Harrelson 1 and 2, where it came up. You had a Lowndes County deputy who was involved in an automobile accident in Montgomery County. And so the court, on a motion to dismiss, said, no, there's not enough facts in the complaint. It could have been engaged on a personal errand or something like that. So it went back down. A motion for summary judgment was filed with an affidavit stating that he was traveling to the Department of Forensic Sciences to deliver evidence. Then the court said, that's acting in the line of scope of your duties. In the
Hang on, Mr. Webb. Does that answer your
Golden-
question?
Thank you, Your Honor.
Mr. Webb. All right, that concludes our arguments for today. I was very remiss in introducing 2 other important members of our court and how they work. We have our Marshal Earl Marsh, who was just about to get up and gavel us out, who is helps take care of, they set all this up for us, and he takes care of all of the building and makes sure that we're all safe at all times. And then, of course, we have our, with somebody we could not function without, and Megan Rodebeck, our clerk of court. So I apologize to both of y'all for leaving you out last time. So, all right, we are adjourned.
All rise. Court is now adjourned.